Good morning, everybody, and welcome to Complaince Corner with John Hanson. Today is Thursday, September 3rd. Another wonderful sunny day to be talking with my good friend, John. John, how are you doing today?
Doing great, thank you.
Awesome, awesome. Okay, so we have a good topic today. We're going to talk about everybody's favorite subject, earnest money. Specifically, when there's an earnest money dispute. How many calls do you think you get on that topic? Like say a month, John, what do you think?
Well, I would think 2 to 3 a week. So
That's a lot.
There you go.
That's a lot. Gotcha. So here's the thing that I think happens to a lot of agents, regardless whether you're representing a buyer or you're representing a seller. We get emotionally invested in this with our clients. And I think sometimes and you tell me if this happens, sometimes we as agents, either representing the buyer or the seller, we think it's our job to help facilitate, if there's a dispute, to facilitate that. Does that come into play sometimes, Sean?
Yeah, it comes into play all the time, and I understand it because we've got really good agents in our company who are caring about their clients and want to help the client out with their earnest money situation, and we just we have to kind of take a step back from that emotion and realize that we're bound under certain restrictions in doing what we're doing to help them get their earnest money back because we are not licensed to practice law. And so we could end up, getting ourselves in bad trouble. And so I know it's hard to just say to the client, I can't help you with this. And so we have to have some good dialogues to help the client understand we want to, but we are not able to because it's the illegal practice of law for us to engage in that, and so we can't really do that. So one of the things we can let them know is we don't hold your earnest money. We as a broker, we don't hold your earnest money. Because we don't hold your earnest money, and an escrow does, they're the only ones that can do anything with it. There's nothing we can do. There's nothing you, the broker, can do. There's nothing I, the designated broker, can do. So we just need to understand, I think, the steps that need to be taken. And the first step that needs to always be taken is to have the client email over to the escrow a request or demand for their return of their earnest money. That's the first step, because what that does is it triggers escrow's RCWs. Mm-hmm. And so they have to send out, following their RCWs, have to send out notice to the other side, see if they respond back. And then, there's a process that they have to go through. And nothing starts until your client sends over that request for the return of their earnest money.
Okay, so let's do a scenario here. And I represent a buyer, let's say. Okay. Let's role play this a little bit, John. So John, my buyer, their financing fell through, and we had a 30-day financing, and we were well within the 30 days. It was 25 days in. And my buyer wants to cancel the contract, and they want the earnest money back. So I let the listing agent know that, and the listing agent says that she's not going to give us our earnest money back. What do I do?
The first step, of course, is always to make sure we have sent that termination notice, because that's essential. So before we do a 50 or 51, to direct the earnest money, we always have to make sure that we've sent notice of termination. So in this case, we would have sent the 90I, and we would have included the date. The letter from the lender that includes the date that the application was made and that they had sufficient funds to close, and that they and the reason for the loan denial. And then once that's sent, so the agent is going to be the other agent, the listing agent, is going to be thinking they're doing the right thing by sticking up for their seller who's upset, and they're getting on board with their seller, and they're saying, yeah, we're not going to sign anything because, you know, we've had this house off the market 25 days and we've been damaged, and we need to have that earnest money. And, you know, they go on. So I would just say something like this. I would say, you know, the unfortunate thing is that none of that you've shared with me is contractual in there at all. None of it is. What is contractual is exactly what we have done. And so if this goes to an earnest money interpleader, then we have on page 4 of our purchase and sale contract, we have a paragraph P that addresses lawyer fees and legal fees, court costs, and basically also includes specifically interpleaders. So it says that the interpleader court costs and legal fees and everything else can be reclaimed by the winner of the earnest money. And so we had a situation in Spokane County just 2 years ago that resulted in a decision in favor of the buyer, and it was your exact same situation. It was a financing situation, and there were $50,000 of lawyer fees on each side in that long dispute over a $3,000 earnest money, and ultimately the buyer won, and the seller was ordered to pay the buyer's lawyer fees for him and court costs. And so, so I would say to that other agent, I would say, you know, your seller can just, you know, you can try to help your seller shred the emotion and get to the contractual legalities of this thing, because it could end up costing them a lot more money than just returning the earnest money. It was never theirs to begin with. It was our buyer's earnest money, and they protected it with this contingency, which they've exercised, and now it's time to have that returned.
Okay, great. Okay, so let's flip that script for a second. Now it's same scenario. I represent the seller, and we got notification from the lender. So they were sending in their termination, but we got notification from the lender that there was a 5-day application process, and they made application on day 8. Okay, so I represent the seller, and they did not fulfill all 3 requirements. The buyer did not fulfill all 3 requirements, and now my seller wants to keep the earnest money.
Okay, so would I be helping you as the listing?
The listing agent. So yeah, you're my designated broker as the listing agent now.
Yeah, so I would probably explain what I just did, you know, what the risks are, but I believe that our cause is just. You know, I'm not a lawyer, I can't give legal advice, but they didn't make their application in time, what they said contractually they would do, so they really didn't fulfill the terms of the Form 22A. So they're in breach. Now the problem with that's such a great question, Kole, because the problem with that is that if objection is not made soon enough to that, then we know that through the legal doctrines of promissory estoppel and detrimental reliance, that because we've allowed it to proceed forward and not objected, it may be looked at as being waived, you know, legally being waived as far as being late for the application.
Absolutely, because so many people don't do the follow through of the loan status, right? And so what you're saying is really interesting, John, because I think there's several parts that agents really need to be aware of. Understanding what all the mechanisms are as far as earnest money in the Form 21, as well as all of the financing addenda, and then also regarding termination and the difference between termination and rescission. I think so many agents, they'll just send in a Form 51 and think that is terminating the contract when it's not necessarily doing that. So, you know, I always say the adage, the person who knows the forms best always wins. And it sounds like that's kind of where you're going with this, right?
Yes, you're absolutely right. So always send in that notice of termination first, and then it can be followed or accompanied by the 50 or 51
Yeah.
And then be aware also that on page 2 of our purchase and sale contract, we have lines 35 and 36 that say that of that in paragraph B that if one party is required to sign for the release of the earnest money and doesn't do it, they're in breach of contract. And so because they're in breach of contract, that allows, in many cases, the buyer to now sue the seller.
Mm-hmm.
And now this paragraph P I was talking about for reasonable attorney fees comes into play, and it can become a real problem. And sometimes we just have to have a relaxed, calm conversation with the other agent to just point some of those things out, because a lot of them don't know. And they just have that same emotion we have to protect our client. They want to protect theirs. And sometimes I refer to it as talking them down from the ledge, because that's really where they're going to be in many of those situations. But we have to be super careful. My emphasis here, we cannot practice law. We are not allowed to. Just got an email from Annie Fitzsimmons, in a response to an earnest money dispute like that, stating really strongly, that we have to stay out of that. It's not any of our business.
Mm-hmm. Yep. Gosh, John, this is such a great topic, and there's some complexity to it. So here's the thing, guys. Whenever in doubt, first of all, call John. That's what he's there for. He's there to support you. And you can just tell by how he can name off what paragraphs and what pages and what lines that he knows what he's doing. And I tell you what, I would always do that, John, that's for sure. And you're not an attorney. Don't play attorney. Don't play one on TV. That's who you are. All right, John, thank you so much. As always, I always enjoy our talks on Thursday. Wonderful Labor Day weekend. I hope you have a fantastic weekend planned.
Thank you.
All right, my friend. I'll talk to you later. Bye.
Bye-bye.